Okay, so I see we have a good number of participants in, so I think I'm going to get the ball rolling because we have just an hour today and I'm conscious that we have an awful lot to cover. So I'm going to just kick off now by introducing everybody. So firstly, I'd like to welcome you all to the launch of the Speak Up 2020 report. This is Transparency International Ireland's third report, and we are so delighted to have you all with us here today to share the results of that particular report. My name is Stephanie Casey. I am the manager of the Integrity at Work programme. I'm going to be the moderator today, and I'd like to kick off by introducing our speakers. So I'm delighted to welcome John Devitt, who is the founder and chief executive of Transparency International Ireland. I'm also delighted to welcome Judy O'Loan, who is the Managing Solicitor of the Transparency Legal Advice Centre. And we are delighted to be joined today by Professor Rob Gillanders, who is Associate Professor of Economics and Co-Director of the Anti-Corruption Research Centre at Dublin City University. So you're all very welcome, and thank you very much for being with us today. So as I said, we have approximately an hour. If we have lots of questions and lots of engagement from you, we are very happy to stay with you for a little bit of extra time past 11 o'clock if you can stay on with us. But we will try and stick to the hour that we have allotted for our presentations. We're going to kick off with John. He's going to give a short overview of the main findings of the Speak Up 2020 report. We will have some time for questions on the report just after John's session. And then we're going to move to Judy, who is going to share her observations on recent cases taken under the Protected Disclosures Act, and that's Ireland's whistleblowing legislation for those of you who are not familiar with it. So Judy's going to go through some of the recent cases and share some of her observations around those. And then finally, we are going to return to Rob and to John to very appropriately on World Anti-Corruption Day have a discussion around mechanisms for countering corruption and fraud, with particular reference to the Hamilton report, which some of you will be familiar with, which was published just last week. Now, we really do welcome your questions. You'll see a Q&A button at the bottom of your screen. Please feel free to ask us a question at any stage using the Q&A button. If you'd like to share an observation with us, you can use the chat button. But for any questions, please just pop it in the Q&A and we will try and get to your question during the session. So thank you very much again for being with us, and we'll kick off now with John's presentation. Thank you, John.
Thank you, Stephanie, and I will share my screen. I hope you can all see that there. Thanks again for joining us here for the launch of what is our third Speak Up report, as Stephanie said, the first being published in 2015. And the report, the 2020 report, is largely based on data collected through our Speak Up helpline and based on the experiences of about 566 clients between January 2017 and January 2020. It does take some time to analyze and audit that data, so there's always a few months lag, so we don't have the most data available for analysis. So I'll talk you through the main points, but before I do, I want to explain why we work on whistleblowing. And we decided to focus on whistleblowing because it is probably the most effective way of exposing individual cases of corruption, according to the Association of Certified Fraud Examiners in the US. At least one in 4 cases of fraud are exposed by people working within organizations, sharing information, tip-offs, exposing wrongdoing, leading to investigations. And this can lead to a virtuous cycle by which people are deterred from engaging in wrongdoing, knowing that their colleagues may speak up if they are engaged in malpractice. It makes it easier for cases to be exposed, which can then be acted upon by either management inside an organization or law enforcement agencies, and then can help people from learn from those experiences, which in turn can help prevent corruption from happening again. We started our work in earnest on this issue in 2009, 2010. As you see us outside the steps of Leinster House there, holding a giant whistle. We were publishing a report which highlighted shortcomings in legislation, calling for one law that would protect workers across multiple sectors, whether it be public, private, and non-profit, and would offer people the clarity they need, the assurance they need to be able to speak up with some confidence that both the concerns they raised will be acted upon and they won't suffer as a result. So in 2011, we launched our Speak Up Helpline. Since then, we've supported around 1,700 people. About 1 in 3 people who come would be categorized as whistleblowers, as you see in a moment. But since then, we've expanded the program to also provide support to employers through our Integrity at Work program, engage with organizations and create safe working environments for whistleblowers. And in 2016, we also launched the Transparency Legal Advice Centre, which is an independent law centre regulated by the Law Society of Ireland, which provides free legal advice to people making protected disclosures or those who have made protected disclosures. So to move on to the report itself, based on the analysis of data from just under 600 clients between early 2017 to the beginning of 2020, you'll see that 1 in 3, 33% of clients were whistleblowers. The largest number of those coming to us would be categorized as people who believe they were victims of fraud or some type of malpractice. And the remaining clients would be categorized as witnesses. The majority of people are coming to us are male, and that reflects trends around the world. It seems to be the case that in many instances, whether or not more men are whistleblowers or not is not known, but we do know that the majority of those who tend to come to our helplines are men. The majority of people coming to us are also aged between 40 and over 55. A very small number of people, young people, are coming to us for support or advice. And it's no surprise to find that the majority of people coming to the helpline are from Dublin, though we do seem to see a disproportionate number of people from the capital or the metropolitan area coming to us, considering, say, 1 in 4 people are from the Dublin area. More than 40% of all our cases are from Dublin. I think it's largely down to a large number of public bodies in the capital and companies and non-profit organizations too. So what were the top whistleblowing categories between 2017 and 2019? So you'll see from the chart here, during that period, the largest number of people contacting our helpline were from the non-profit sector, from charities. The next largest number from health sector, and then the third from the education sector. The bulk of those calls from the largest number of calls from the not-for-profit sector related to misuse of funds. There were a smaller number of reports of fraud and false accounting. And likewise, in the health sector, we were able to break down the analysis by looking at the types of concerns raised there too. And the majority of those in the health sector were reporting risks to patient safety, health and safety, as well as we also received some concerns raised about maladministration, misuse of funds too. We've been at pains, or we've made a point, or pains to point out that this isn't a reflection of any bigger problem within the charity sector or even the health sector than in any other employment sector or industry. It may be reflective of the fact that people within the sector are more sensitive, are more aware of the need to speak up, may feel safer in speaking up in some instances. Their employers may be encouraging them to report concerns. Likewise, in the health sector, we see these trends in the UK too. It's such a large employer that it's inevitable that we will receive a large number of concerns raised from within the sector. In many cases, people come to us are reporting concerns about what could be matters of life and death. Patient safety is a critical issue, and it's not something that people are likely to sit around and mull over reporting. They're much more likely to take action in response to concerns they have and seek advice. The majority of people, or the largest number, not the majority, but the largest number of people who contacted the helpline during the period were reporting regulatory breaches, whether it be health and safety or data protection. Second biggest number related to whistleblower retaliation. And again, as was the case in 2017, the health sector represented the largest number of those coming to us reporting reprisal. Why that's the case is not clear. But again, it seems to reflect trends worldwide, where we see, for example, a very large number of NHS whistleblowers in the UK reporting reprisal to our partners at Protect. And again, this is high in the health sector, and there is sometimes a disconnect between management and those working on the front lines, working in providing support, whether it be just, you know, and in their respective health services. So that may have bearing on the high rates of retaliation, and the disconnect between management and frontline staff may be one reason why so many cases of retaliation are being reported. Again, we saw a relatively high rate of retaliation within Garda Síochána, although the number of cases there weren't that high. I think we received 8 complaints over the period from either members of civilian staff, and a relatively high rate of retaliation reported in banking and finance. So what action did we take in response to these cases? Well, in the majority of cases, people are just coming to us for information or advice. They're very often looking to explore their options before they speak up. They may want to know to whom they can report a concern about poor service in a public body or wrongdoing in that public body. In many instances, they will be referred on to the relevant regulatory agency. They're not necessarily looking to blow the whistle. The majority, as I said, of our clients are not categorized as whistleblowers. Essentially 1 in 3 are. The majority would be either members of the public or service users who are looking to raise a concern about management, the performance of a public body, or maybe victims of fraud or types of malpractice. In 15-16% of cases, they're referred to a legal advisor, usually the Transparency Legal Advice Centre. And over the period since it was launched, the Law Centre has taken on about 90 clients. Majority of those who were offered appointments do engage. While we've seen a drop off in the number of clients that are being taken on since 2018, many of those clients are still on our books or on the books of the Law Centre. So many of those clients do need long-term support and guidance through the process. So those are some of the highlights of the report. There's lots more in there. The link and the report itself should be available by now. It's not, we'll add it in the chat or forward the report to you. But I'm happy to take any questions you might have for now before we move on to Judy.
Thanks, John. And I should have mentioned actually at the start, probably you can see it on your screen, we are actually recording this session as well. And it's being live streamed via Facebook. So that's good news for anybody who couldn't actually make it with us live today. You will be able to listen back to this as it's all being recorded. John, I was just about to say we haven't received any questions, and one literally just popped up. And this is a question from Peter Behan. I think all the panelists can see it there. Peter asks, would Transparency Ireland support whistleblowers who decide to take protected disclosures themselves through the PAC or government public bodies, but don't go through Transparency Ireland? John, would you be able to respond to that question?
Yeah, we can provide advice to anyone who is who at any stage. If someone is reporting directly to the Public Accounts Committee, you don't have to come to us in the first place for us to be able to provide support. And as we said, the helpline is an information referral and advisory service. We only have the resources to be able to take on a very small number of cases. As you see from the presentation, we were only able to take on one case during the period out of 600 to provide advocacy support in the way we provided such support to Maurice McCabe. But anyone is free to contact us at any time, either drop us a line or call the helpline, and we'll do what we can to help. So yeah, to answer your question, Peter, no need to contact the helpline before you report to anyone else. You can come back to us anytime.
Absolutely, and actually we'll share the helpline contact details with everybody on the session today, and we should also mention that you can contact us, anyone can contact us online as well at speakup.ie. We actually have a secure online form for contacting us, so if people don't feel comfortable contacting us by phone, we have an online option as well. Alison Matthews has asked, has said thank you for the presentation. Thank you, Alison, and has asked, did the Speak Up Helpline accept anonymous reports during this reporting period? Do you have any information on cases reported anonymously? No, and people aren't necessarily reporting through us. I think we want to make the distinction, I should have made it at the beginning, between a hotline and a helpline. So you're not reporting through the helpline, you're coming to us. Generally speaking, people are coming to us for advice or support. And I don't, Alison, have the details to hand of the number of people who didn't share their identity. That would be quite common for them not to do that. And in fact, when people call up the helpline for the first time, we'll often advise them not to share their identity, because at that point of initial engagement with the helpline,
there are no formal protections and legal protections in place for you. It's only when you're engaged by the law centre that you are afforded solicitor client privilege. So many of them will use a pseudonym, or we'll give them a pseudonym. It would be, and we wouldn't use anything as obvious as Alison M, but we would use a different pseudonym to protect the identity of our clients. I don't have data to hand, by the way, on the number of people reporting concerns anonymously to their employers. That we just don't have access. That's the kind of data we don't have access to. But we know from our Speak Up, our Integrity Work Survey, the last one we conducted in 2016. I don't have the figures, but they are available in the last report. The large proportion of people would prefer to remain anonymous initially, essentially, certainly in the initial stages of the reporting process.
Thanks, John. We have a third question, but actually, if you don't mind, for this third question, it's a question about the forthcoming EU directive on whistleblowing, and we're actually going to look at that a little bit later on in the session. So we'll come back to that question if that's okay. And that gives me the perfect moment then to introduce you to our next presenter, Judy O'Loan, Managing Solicitor of the Transparency Legal Advice Centre. As John mentioned, Transparency International Ireland established an independent law centre 5 years ago now to provide specialised free legal advice to anyone wishing to disclose wrongdoing under Irish legislation, and particularly to people wanting to make a protected disclosure under Ireland's whistleblowing legislation. So Judy, I'll hand over to you to talk us through some recent case law.
Hi everybody, and thanks for joining us. I think I'll just start with just premising a little bit about the work that TLAC do, and just so that people understand. So we take our referrals from the helpline and we give people essentially legal advice on whether what they wish to disclose would fall within the definition of a protected disclosure or not. And this is our opinion on whether we think that if they make their disclosure, they will be protected. Now, clearly the ultimate decision on whether something is legally a protected disclosure or not falls with a judge or an adjudicator in the tribunal. So we are just advising people. Then once they know that they are likely to be protected by the Act, they would draft the protected disclosure themselves. We would help them draft it, and then we would provide support through the disclosure process. So through the investigation and the investigation report. And if, you know, our clients aren't happy with the outcome of that, then we would advise on further disclosure options. So, you know, we can have clients on our books for 4 or 5 years. And I mean, just in terms of the PDA in practice, we do not do litigation. So we cannot assist clients taking or seeking a legal remedy at the WRC or the Labour Court or any of the other courts. But clearly we keep a close eye on all of the case law that comes out of the WRC, the Labour Court, Circuit Court, the High Court, because that will have an impact on the advice that we're given. And obviously it's kind of the interpretation of the Act and, you know, whether things are likely to hit the evidential bar of a protected disclosure or not. So we monitor particularly the WRC and the Labour Court quite carefully. We don't do litigation, and that kind of brings me to just premising, you know, our research is possibly not entirely scientific. We monitor the website of the WRC very closely, and you know, this is the analysis that we have come up with just based on what we've been doing. And I know that Lauren Kierans has been watching this very, very closely. I believe she's in the audience, and she's going to publish research findings on this that will be, you know, probably more drilled down, more academic, better framed than ours, which is very much, you know, as an assistance to our day job. And we have, you know, one solicitor position at the Transparency Legal Advice Centre divided into 3 people. So we are part-time, and we reckon we probably get more out of 3 part-time staff than we would out of 1 full-time staff. So it's really economics. But we So this is very much just part of what we do in our day and daily in order to, you know, assist those people making protected disclosures. So that just gives you the backdrop in terms of what I'm going to say. So, you know, I think the headline for all of us, and the thing that's probably worrying us practitioners, you know, who work in this general area, is the low level of success rate of those seeking a legal remedy, particularly in the WRC and the Labour Court. Now, we have done our count, and it's literally 1, 2, 3, 4, 5 type count. So we think that in 2016, there were 8 protected disclosure cases and 1 was successful. In 2017, there were 21 cases and 3 successful. 2018, 44 cases, 1 successful. 2019, 63 cases and 7 successful. So from 2016 to 2019, we think out of the 136 cases, there were 11 of which were successful. So that's 8%. So that's low as far as we're concerned. And we wanted to understand a little bit more on why this has happened. So as I say, Lauren's research will be published on this soon, and she was very kind to share with me her headline figure, which is similar. She looked at the period from the 15th of July 2014 to the 16th of July 2020, so over a 6-year period. And she looked at 156 of the 163 decisions and found that only 19 were successful, so that's 12%. So we're talking kind of, you know, in and around that figure. So we looked, and one of the things that bothers us in terms of some of the cases that, you know, may be retaliation against a whistleblower making a protected disclosure under the Act are time limits, are limitation. So some of this technical legal stuff, many of those seeking a remedy in the WRC or the Labour Court do not have the benefit of legal representation. So they may fall down very early on in the process. So time limits is an issue. There is a 6-month deadline for issuing a claim for penalisation and unfair dismissal under the Protected Disclosures Act. There is a 21-day time limit for seeking an interim relief in the Circuit Court if you have been dismissed until the WRC can more or less hear your case. And so there are a few cases, you know, about limitation in the WRC. The one that troubles me most was the case of McPartland v Waterford University Hospital. Now, this was a nurse who had concerns about hygiene control within Waterford University Hospital, and the WRC said she was out of time for a penalisation claim. She had issued her proceedings within 6 months of her constructive dismissal, and the WRC held that the time ran from the last act of penalisation rather than the act when she handed in her notice, because, you know, she felt she'd had enough. And so essentially she potentially had a claim for constructive dismissal. So the WRC held the time ran from the last act of penalisation rather than the date she handed in her notice. And this bothers me because I think that it's quite difficult for a practitioner and for anyone looking at a case to actually pinpoint that last date of penalisation. I mean, is it the last time that nobody sat with you in the canteen? I mean, is it the last time, you know, that somebody walked past you in the corridor? You know, it is very, very, very difficult to pinpoint that. It tends to be, you know, a continuous build-up of penalisation. And the other reason it bothers me is that, you know, if you look at the definition of penalisation under the Act, you know, the first subsection of that definition is suspension, layoff or dismissal. So that's kind of one of my problems, let's say. Now, we did have some clarification from Cullen and Kiltiernan Cemetery. It was the Circuit Court who was asked to assess whether Mr. Cullen could still claim interim relief in his dismissal, and he had made his claim 3 months after 3.5 months after being made redundant. He claimed he'd raised concerns about planning status of an ash burial site in Kiltiernan Cemetery. So Schedule 1 of the Protected Disclosures Act does allow courts to extend the 21-day time limit, but never actually outlined what factors might justify an extension. So this was the first time that we got some, you know, guidance on that. Judge O'Connor outlined 10 factors which the court should take into account when deciding whether or not to grant an extension of time. So these are, and I'll just read through them: the nature of the disclosure, the nature of the dismissal, the length of time since the 21 days expired. So, you know, if you're 22 or 23, you know, you might kind of get away with it. The whistleblower's capacity and ability to process the court application, the nature of the employer and employee relationship, the extent of legal advice afforded to the whistleblower. So, you know, the fact that they weren't getting legal advice would be taken into account by a judge. And going back to the McPartland case, she did not have legal advice, and she was 2 weeks beyond what the WRC held to be the last act of penalisation. So I think that was a kind of a harsh judgment, to be honest. Reasons for the delay, merits of the case, take an account of all the circumstances of the case, and, you know, just an equitable, that lovely wrap up. So as I say, time limits are a problem. You know, we do advise on limitation as soon as we get a client on the books in TLAC, even though we don't seek the remedy for them, because it's so utterly important and it's so quick. You know, 6 months is not long. So then we have the definition of wrongdoing. So this is kind of going back to our protected disclosures definition, which is essentially our bread and butter. I kind of consider some of the information to be sieved through, and we hit gold on the definitions, basically. So some of the case law talks about the wrongdoing, and the courts are looking for something fairly serious. I mean, breach of policy, they have said, is just not enough to hit that bar of relevant wrongdoing. Now, I mean, we have that very wide gross mismanagement, gross negligence for public sector. So, you know, I'm not sure if maybe a series of breaches of policy would somehow point to gross mismanagement. And that's something that we would probably all welcome some clarification on. So as I say, the courts are looking for something fairly serious, a degree of gravity. And in some of the cases, you know, the claimant had not really given enough information about the wrongdoing in their disclosure. So again, this is where TLAC, we believe, provide really, really important legal advice, in that, you know, you have to pass that evidential bar of reasonable belief. So, you know, you do need a factual account that hangs together and, you know, is credible. So then there were some, you know, it's disappointing to see some of these cases just falling on, you know, legal points. You know, procedural errors, you know, was another problem in some of the cases that were taken before the WRC, and often with the litigant in person. So they may make a claim under the wrong act. For example, a claim for unfair dismissal for having made a protected disclosure needs to be made under the Unfair Dismissals Act, not the Protected Disclosures Act. So, you know, some of these things, a litigant in person looking at the website just would not have, you know, the information, you know, in order to be able to, you know, submit their claim correctly. Then we have causation. So a claim for penalisation or unfair dismissal hinges on for having made a protected disclosure. So you have to link it, and lawyers talk about the causal link, the chain of causation, and it's sometimes known as the but-for test, where the penalisation would not have happened but for the protected disclosure. And I think that this is probably one of the most common causes for failure, where the WRC finds that there is no causal link between the penalisation and the dismissal and the protected disclosure. And we are hoping that the transposition of the directive will help here, because it will be on the employer to establish that any alleged detrimental action was taken on duly justified grounds, rather than for the employee to establish that the detrimental action was linked to the disclosure, would not have happened but for the disclosure. So while we're kind of, you know, surveying the WRC and the Labour Court, we also just keep a tally on the level of awards. You know, it kind of contextualises the work for us quite a lot. I mean, there's maybe not a lot scientifically that we can say, you know, in 2009, 7 awards ranged from 2,500 to 35,000. You know, it's hard to draw any particular conclusions from this. I mean, I think we would just reinforce that the level of award needs to have a deterrent effect on an employer, you know, in order for them not to penalise or treat their whistleblowers badly. And we would prefer a just and equitable in the circumstances, rather than, you know, the 5-year cap on the unfair dismissal claims. So that's the other then interesting bits and pieces from the legislation, or from the case law, sorry. There was Section 53B of the Protected Disclosures Act states that a breach of a legal obligation arising under a worker's contract of employment is not a relevant wrongdoing. So, you know, we can have some cases where we're looking at this and, you know, wondering. And there was a case, a carpet weaver via textiles company, which clarifies that, you know, if it is a systemic issue, if it affects more than one employee, then you are within your rights to make a protected disclosure about that. And then we have the Section 5.5 exemption as well, which says that if it is your job to detect, investigate or prosecute wrongdoing, you can't make a protected disclosure about that wrongdoing unless it relates to an act or omission on behalf of your employer. And this was looked at in Clark in the High Court in July, and a judgment was delivered, which, you know, we were all quite happy about. Now, if we have a client coming into the law centre and they say they're an auditor, they work in finance, you know, they're an accountant, that kind of thing, you know, we immediately think, you know, is this potentially, you know, a Section 5.5 exemption? So this Clark decision actually was right in the heart of that. The disclosure in this case was a financial controller, and he raised concerns over unvouched expenses, payments made to directors, personal spending on company credit cards, etc. And he said difficulties ensued, which caused him to raise a grievance in October 2018, followed closely by 4 performance reviews and a suspension in April 2019. So, you know, when you think about that causal link, you know, everything is stacked up. This all happens sequentially, and, you know, it doesn't happen too long after the protected disclosure. So, you know, from a lawyer's point of view, he has a strong causal link here. He was dismissed on the 15th of May 2019, and he was awarded interim relief from the Circuit Court. So he got in on his 21 days and got his pay and benefits maintained until the WRC could actually hear his case. Now, there have been problems with the WRC and the length of time that it takes for cases to be heard. So there was a number of adjournments, and I probably think the employers were thinking, right, we're still playing this guy. The WRC, you know, are messing around, or, you know, taking their time, or, you know, COVID is hit, and, you know, we can't get a date. And so they sought to appeal the decision of the Circuit Court to the High Court. And the judge held that the wrongdoings were as a result of an act or omission on behalf of the employer, and therefore what Clark had disclosed could be a protected disclosure. He distinguished the case from the decision of the Labour Court in Donegal County Council versus Carr, which was one that held that that the disclosure there was Section 5.5 exempt. He pointed out that the wrongdoing in Carr was by other employees, and it was not by the employer, and so the act says act or omission on behalf of the employer. Therefore, you know, it was different from Clark, because the problems with the finances were with the employers fairly squarely. So, so really some really welcome clarification, you know, coming from that decision in Clark, and I would advise you, if you're working in this field, to have a read of it. So the judge restated that there's no necessity for a disclosure to be stated as a protected disclosure. I mean, to my mind, you know, the guy who comes into the office and speaks to the line manager and says, you know, I'm a bit worried about this invoice, it doesn't look real to me. I mean, that's, to me, the protected disclosure, you know. So, and the court observed there was no necessity for an employee to consider the situation in statutory terms until after the adverse consequences materialised. Now, the other thing that Clark looked at very carefully was when there is a performance-based dismissal. He quoted a court from the UK Supreme Court and said, you know, that the judge needed to look behind. It was the court's duty to penetrate through any possibility of an invented reason for a dismissal, rather than to allow that to infect its own determination. And he held that the following 8 factors were relevant in determining whether, you know, Clark's dismissal was an invention. So when the performance related issues arose, so as you know, in Clark, they arose pretty quickly after he started to raise his concerns. The intensity of the performance related discussions, he was in and out of, you know, kind of performance reviews, you know, every couple of weeks. The form of the dismissal, he had been summarily dismissed as if guilty of gross conduct, though rather than a procedure. In this case, let me just, following through with the proposed methods. So they talked about various things and how they were going to do and conduct their hearings, and then they didn't follow that through. They were going to have, you know, an independent barrister. Then the independence of the disciplinary hearing, no need, and accountability. So, you know, Clark has resonance for other decisions of the WRC, and where, you know, Section 5.5 has been invoked, and, you know, I think that it probably hasn't been, you know, fully correct. There was a decision made against 2 clampers who were raising concerns about, you know, illegal clamps, and the WRC held that you know, that this was, you know, in their line of work. And to me, it would seem very odd that employees would be, you know, reporting on other employees' work, and that would be their job, you know. And in my mind, you know, the fact that, you know, the employer in this case didn't really, you know, quality control the clamps that were being affixed is potentially an act or omission on behalf of the employer. The other interesting thing about Clark is that the High Court ordered that it would be in the public interest that a copy of its judgment be sent to the Department of Agriculture, Food and Marine, because Clark had raised food safety issues, and the Revenue Commissioners to undertake whatever investigations considered necessary in the light of the allegations made by the employer. And I mean, this is often what, you know, a whistleblower will want. I mean, I think sometimes the reason they invoke the legal remedy is to hope to maybe get some evidence, or just exercise some leverage on their employer, you know, to have a thorough investigation, to have an independent investigation, you know, to have an investigation merely that satisfies them as much as is humanly possible. And, you know, practitioners have often looked at, you know, the protected disclosure and the investigation as one track and the legal remedy as another track. And I know I have certainly viewed it like that. And in Clark, you know, this was the first time that those 2 parallel tracks crossed, and the judge intervened in the investigation process and said, here, you know, you need to look at that. And if it's coming from a judge, I would imagine that they probably did look at it quite seriously. So I think for me, that's everything at the moment. I mean, we will just discuss, you know, the directive, you know, later on, and when we're talking about, you know, how the future landscape looks for whistleblowers. So I hope you find that informative, and if you have any questions, I'd be happy to take them.
Thanks a million, Judy. Literally whistle stop tour there through whistleblowing case law. Thanks a million. I know there's a lot of information there for people to take, and we will share some of the case references that you mentioned there as well. Do you know, I think I will take this question on the e-direct right now, if that's okay, because when I was listening to John's presentation and listening to some of the cases that you talked about, I was remembering, you know, there's a wider definition of penalisation, for example, coming down the line with the EU directive. And for those of you who aren't familiar with this, there's a new directive coming in from the European Union, which will be transposed into Irish law next year, so by the end of 2021. And we did have a question a little bit earlier, and the question was, any comments on the EU directive on whistleblowing, and will it be the GDPR of 2021? Goodness me, those of us who lived through GDPR, that certainly strikes fear in the heart. But, you know, it certainly is a really important moment in time in terms of some changes that are coming down the line for, you know, greater protections for people to speak up about wrongdoing. So, Judy, you might just touch on, okay, the wider definition of penalisation. I think that's probably a good point to kick off. And any other elements of the directive that you think are going to be particularly important in terms of changes, you know, to existing protections for whistleblowers.
Yeah, well, you know, while the Protected Disclosures Act is lauded, you know, worldwide as being fairly comprehensive, you know, I'm looking forward to the implementation of new legislation I mean, for me, and this is just in my daily practice, what I'm really looking forward to is the fact that, you know, there are certain obligations now on employers post-disclosure. So, you know, you have a 7-day response limit to acknowledge the directive. You know, I often, when I speak to employers, and I often say, you know, try and put yourself in the shoes of the whistleblower. You know, if they've come to us, you know, we've questioned it, we've gone through it, you know, we've sieved it, you know, we've refined it, you know, we've identified as close as possible the relevant wrongdoing, and then, you know, they press send, and it's a big moment, you know, and it's a big moment for me as much as it is for them. And then if there's silence, you know, that's very, 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 very difficult to take. So 7-day acknowledgement, and, you know, 3 months for, you know, some sort of report back on, you know, what they've done so far, and diligent follow-up is the terminology in the directive. I would say from my experience in TLAC, you know, that the investigation process is crucial. And I would say from the experience of my clients that they're not involved enough in shaping or framing the terms of reference. The appointment of the investigator is, you know, it's really important. It's really important to involve, you know, the whistleblower in that process. And if they don't rate the investigator from the start, you know, it's going to be a long and difficult journey. I would say some of the time taken to complete these investigations is just horrendous. 2, 3, 4 years, you know, not acceptable. I still see in my daily practice, you know, employers not willing to hand over final investigation reports. The other thing is that, and John and I have talked about this, is like a level of expertise from the investigators. You know, we're getting reports of some technical things, you know, and I would want to see a technical person dealing with that investigation, you know, you know, they just have to, you know, and, you know, if a human resource professional is taking that on, sometimes I worry that they don't have the level of expertise that is required to conduct that investigation. So post-disclosure shape is the thing that I am looking forward to most in my practice. The reversal of the burden of proof, we think, will probably improve that causation issue.
So can you just, sorry, just again, I always have to play the layman here.
Yes.
So can you just explain that reversal of the burden of proof? Because, you know, that is very important. So if you could just maybe...
Yes, so the employee going into the RC has to show that, you know, the penalisation was linked to the disclosure. And so now the employer has to show that any detrimental act was justified. Right. So, for example, some cases in the WRC have fallen down because, you know, the disclosure is saying, you know, they moved me away over there, and, you know, they put me by the window and they took half my job duties away. And you know, some of those cases have lost because the employer has said, oh, well, that was restructuring, you know, so, you know, and the person, you know, on my side of the desk doesn't think that it was restructuring. So the employer now has to just show more diligently that any kind of detrimental action was duly justified. You know, if there was a disciplinary, what was that disciplinary really about? You know, so that is definitely, I think, going to improve things for people taking claims.
Okay.
The extension of the definition of penalisation is interesting. As I say, it still has suspension, layoff, or dismissal in its first line. So I'm going to keep banging that drum for a little while. Demotion, withholding of promotion. I mean, one of the things is a psychiatric or medical referral, and I have seen that in practice, you know, and I am glad that that is now within the definition of penalisation, because to my mind it is a dirty trick, and whistleblowers are in a vulnerable position. You know, one of the services that TLAC offers is, you know, they're looking at this and they're thinking, did I see that? Is that right? You know, is this invoice fake? You know, did they really do that? You know, and it takes everybody a while to, you know, decide, you know, this is off. This is really off. Then they come to me and say, this is what I've seen. Do you think that's off? And, you know, so it goes on, you know. So
yeah, so almost kind of sense checking. They can almost feel like they've you know.
Absolutely. So that's something else I'm looking forward to. There's potentially more measures of support coming down the line, you know, with the directive. You know, they may look at legal aid again. You know, they may extend, you know, access to legal advice before, you know, making the disclosure. And so other measures of protection as well within the directive. So I just think it kind of just puts a scaffold on the protected disclosure.
Yeah, strengthens. Yeah. And of course, the big thing which we should mention as well is that obviously the obligation to have a protected disclosure whistleblowing policy and procedure now extends to private sector companies. Isn't that correct?
That's also true. That's also true. And I mean, the WRC will look at, when they're deciding whether, you know, it is a valid protected disclosure, they will look at the policies and, you know, did the employee follow the policies, you know, the internal policies. So, you know, we always refer to the internal policies when we're given our advice to see what the employer requires, you know.
Yes.
And so, you know, if they're publicly available, you know, it makes our job a bit easier.
Of course. So Charlotte, I saw you had a question there in the chat. What big changes will be required from companies with the introduction of new legislation, updated policies, procedures, etc.? So I hope we've just covered that for you a little bit. There are certainly, you know, there will be an obligation there. There'll be an obligation there for private sector companies as well as public sector bodies, which is currently the case with our current legislation. But you know, the legislation is being transposed next year, or sorry, the directive is being transposed next year. So, you know, as that process unfolds, we will be certainly liaising very closely with the Department of Public Expenditure and Reform, who are tasked with that transposition, and we will be running regular events and webinars next year as well. And we also run training on the Protected Disclosures Act, Ireland's whistleblowing legislation, and the directive under the Integrity at Work programme. So keep in touch with us and have a look at the Integrity at Work website, because we put all of those events up there on an ongoing basis. So if you'd like to attend any of those, that's the best place to find out that information. Listen, I'm going to hand over back to John now, because I'm conscious we have about 10 minutes left. And I'd like to hand back to John and Rob for our next section of the discussion on anti-corruption measures. So John, I'll hand over to you.
Thanks, Stephanie. Just by the way, those obligations and companies won't come into effect until 2023.
Oh, yes.
So, the directive needs to be transposed into law by the end of next year. The obligations on companies with more than 50 staff, we'd like to see all companies, all employers put in place procedures, but those provisions either way won't come into effect for another 2 years after the directive is transposed. But I'll share my screen again and back to the presentation. Thanks, Judy. I just was going to touch on, if you can see my screen, on the impact of the law so far. And we noted it in the report that we'd seen a 120% increase in calls from whistleblowers to helplines since the Act since the legislation was enacted, since the Protected Disclosures Act was enacted. You can imagine we might see another spike in calls after the directive is transposed. We found, similar to the UK, that around 90% of whistleblowers are reporting internally before they report externally, and this is actually based on research conducted, soon to be published, by Lauren Kearns on cases coming before the WRC in Labour Court. So the legislation doesn't seem to have had an impact on, or negative impact for employers who would expect, and rightly expect, most people to come to them with concerns in the first place. In our 2016 Integrity at Work survey, we did note as well that employer attitudes to whistleblowing seem to have improved. We don't have, that's our baseline study. We found that 90% or so of employers said they welcome concerns raised with them. lower still, if it might have an impact on their reputation, you can check our 2017 report for more on that survey. But certainly we seem to think that attitudes more widely have improved, particularly since the enactment of the Protected Disclosures Act. However, only 30% of employers within the private sector, as we noted in the 2017 report, had procedures in place. Only 10% actually, private sector employers had policies in place. So that's something that's a lacuna that needs to be, or shortcoming that needs to be addressed. And as Judy noted earlier on, between 8 and 12% of cases coming before the WRC are successful. So I just wanted to move on quickly to the other work covered in the report, which includes the work we're doing with organizations through Integrity at Work. We launched a new website, integrityatwork.ie, earlier in the autumn, I think October, which provides more information on the program, which, just to touch on it quickly, is based on a pledge that employers take to protect whistleblowers, those speaking up, to take action in response to the concerns and to signpost them to necessary supports or available supports, including the Speak Up Helpline. They undertake a self-assessment of the policies and procedures, and we'll then provide them with guidance and support in improving those policies and procedures. We host conferences and workshops, and also then at the end of the year provide them with a review of their performance or the steps they've taken to improve their systems to promote whistleblowing. So far we've 28 or 29 organizations, 28 joined the program during the period covered in the report, including the Department of Education, Revenue, with Gardaí, the Department of Justice taking part, in charities including Trócaire and ActionAid. More recently, Daisy House joined the program too. So just to touch on advocacy, we focus on 3 areas over the course of the period. We spend a lot of time lobbying against measures introduced as part of the transposition of the Trade Secrets Directive, which watered down protections for whistleblowers here, which made it more difficult for them to justify their disclosures, and meant that in future that if they were to make a disclosure using a trade secret, they would have to justify it by saying they were motivated, or showing that they were motivated by the general public interest in doing so. Spent a bit of time in that. The campaign or lobbying effort was unsuccessful, unfortunately, but this should be addressed in the forthcoming EU whistleblowing directive, which we spent a lot of time working on with our partners at TI, trade unions and Brussels-based trade unions and other civil society organizations, including the Whistleblowing International Network. And I think we got pretty much what we wanted from that directive, including protections for whistleblowers who report directly to regulators or to the media without having reported to their employers in the first place, and the reversal of the burden of proof, as well as measures aimed at ensuring that employers respond to the concerns raised by their workers. Finally, we also spent a lot of time making some submission to the Department of Justice on their anti-fraud and anti-corruption structures as part of the Hamilton review. James Hamilton, as many of you remember, was the Director for Public Prosecutions, and led or chaired a review of the Ireland's measures aimed at tackling white-collar crime and corruption. And we made a recommendation. I won't go through all of them here, but to summarise, we argued that Ireland needs a national anti-corruption plan, essentially, to tackle the problem. We need a more coordinated response to addressing the issue amongst state agencies. We need to work in partnership with civil society organizations, or the government needs to work in partnership with civil society and other stakeholders, including business. And we also argued for the collation and sharing of better data, intelligence-led policing, which means that our law enforcement agents, essentially the Gardaí, aren't sitting around waiting for reports of corruption to be made, that they're more proactive in identifying trends and red flags and investigating or gathering intelligence on that allows them to intervene in a much earlier stage. And we also called for the establishment, or suggested that the government looks at the establishment of an independent anti-corruption bureau, similar to the Criminal Assets Bureau. We can share the link to the report itself that was published, I think last week or the week before, by the department. But essentially, they seem to accept as 6 of our 10 recommendations, or 7. I'm struggling to count here. They didn't touch on or recommend a corruption immunity program, which we've been calling for since 2009, similar to the cartel immunity program, that would offer some immunity for cooperation with Garda investigations for witnesses coming forward. It's important that we are able to help break ranks of those who are conspiring to engage in corrupt transactions or corrupt activity. That's probably because it is conspiratorial crime. It takes place behind closed doors, and it's highly unlikely that even whistleblowers are going to expose it, because those who are engaged in corrupt conduct are often those who are likely to share information on such cases are likely implicated in the first place. So we need to think imaginatively about how we help expose those cases. Likewise, they didn't accept the need for deferred prosecution agreements, which are in place in the UK and the US, and which allow companies essentially to reach an agreement with prosecutor that they will put in place measures to address corruption, forego prosecution against the company, and mean that we can hold corporations to account in a way that we can't right now, and do so without also allowing those personally responsible for engaging in those corrupt transactions to get away with it. So they didn't accept that point, and neither did they accept the need for an independent anti-corruption bureau. We'll come back to this with Rob, and just Stephanie, I am aware of time, but if people want to hang on, we'll spend a bit more time discussing this. So I'm sure Rob doesn't. Rob, you're all right hanging around for a little while longer.
Yeah, at your disposal, John.
Yeah, I think we said at the beginning, John, we probably have an extra sort of 10, 15 minutes or so over. So hopefully, I see the majority of people are still with us. So hopefully they can.
We can hang on for a while. So this is a summary of some of the additional recommendations that the review made. Like I said, they seem to accept the need for a multi-annual strategy or plan. They will establish an advisory council, which reflects our call for, our response to our call for a multi-stakeholder forum, as well as a forum of senior representatives and a joint agency task force, as well as sharing of better data amongst agencies to help them identify wrongdoing. They also argued for an increase in resources for the Garda National Economic Crime Bureau, essentially the Garda Fraud Squad, and the Standards and Public Office Commission. We had called for the enactment of the Public Sector Standards Bill of 2015, which is legislation that lapsed earlier this year, large part because of political opposition in the Oireachtas to enhanced disclosure. It controls better disclosure and enhanced controls against breaches of ethics legislation, which would have also meant that the Standards and Public Office Commission would be replaced by a Public Sector Standards Commission and a single commissioner to oversee those investigations. And there's lots in there. I won't go through them all. I guess our time would be better spent discussing this with Rob and you as well, if you have any comments or questions or suggestions on how we might tackle corruption more effectively in the future. I'll let Rob come in here, I guess. Rob, what was your take on the report or the review overall? What did you see was good? Where were the shortcomings?
Thanks, John. First of all, happy Anti-Corruption Day to everybody. And on Anti-Corruption Day, it's very important we appreciate and recognize the great work John and his team have been doing for a long time. Every country needs a good chapter of TI, and we're very lucky to have a very good chapter of TI. So thanks to all of you for that. Yeah, like John and TI, we in the DCU Anti-Corruption Research Centre put in a submission to the public consultation, and with similar suggestions to John. What I really like about it is they seem to be taking corruption seriously, and while you might quibble over some of the details, there is a sense that there's forward momentum now in terms of tackling this problem, which is important because as a small open economy, it's really important that we fight corruption. Foreign investors, multinationals do not like corruption. It's one of the least ambiguous results in all of social science, so it's important we get it right. It's also the case that corruption particularly harms the vulnerable. They bear a disproportionate burden of corruption. Children, disadvantaged groups, all suffer particularly badly from corruption. So it's important that they're taking it seriously. Things we liked was the suggestion to establish the advisory council and collect and analyze proper data. You know, an economist, you know, all about evidence-based policy. And if we track down where the corruption is and what type of corruption there is, we can start to develop better interventions designed on technology or insights from behavioral economics. So if we understand the problem, we can treat the problem more effectively. So, you know, and there's stuff in there about, you know, I know SIPO has its issues, but the suggestions to further resource it and collect better data means things like, you know, the disclosures that the declarations of interests that politicians make every year, generally dumped on SIPO's website in one 400-page scanned PDF of handwritten notes. I can't do anything with that from an academic standpoint. It'd be too costly to extract all the information. So digitizing that and having a proper system opens up new frontiers to kind of understand what's going on. So I like that. One thing I didn't like, or I was disappointed by the absence of it, I suppose I should say, was something we'd put into our submission, which was the importance of strengthening press freedom in Ireland. Press freedom is really, really important in terms of fighting corruption, because the free press has a kind of a free market incentive to go out and find corruption and expose it, right? It's kind of a nice, clean incentive that economists like. And so more press freedom, you tend to find less corruption. Not just perceptions of corruption, but according to some research we did in the research centre, lower actual experiences of corruption. So we'd suggested that things like Reporters Without Borders suggest every year for Ireland, looking at our defamation laws, examining what regulations are around Gardaí speaking to the media. All of these things would be reasonably straightforward, or at least on the face of it straightforward. And there's always, Judy, you correct me on the law ever being straightforward, I'm sure. But you know, these are things that are out there as anti-corruption interventions that we should have taken into account, I think. And you know, in the next review, I hope they form a deeper part of it. Also, I think John might agree with me on this. The lumping in of corruption with other forms of fraud is somewhat regrettable, because if you want to tackle Again, if you want to kind of tackle a particular disease, it's important to focus on the disease and diagnose it and come up with proper medicines to treat it. I was struck by the data from the Speak Up report. John pointed out that the not-for-profit sector were particularly intensively using the service, and that was because it's plausible that people who work in the public and the not-for-profit sector are a different type of people than people who work in other sectors. And that's why if you target corruption as distinct from fraud or white-collar crime, you can design better interventions that target the kind of the incentives of the kind of people who commit corruption as opposed to white-collar crime. In other words, people who work in the public sector as opposed to people who work in the private sector. Different things might work to curb corruption and instill a kind of a stronger anti-corruption norm in one setting than in another. So I think that a little bit more delineation between the two would have been welcome. So that's kind of some of my headline thoughts on it. As John said, the report came out on Thursday, I think, of last week. It caught us all by surprise, so we're still working through it. But I think it's putting some better data at the heart of decision making is a very welcome recommendation.
Yeah, I mean, you're right. I mean, I think we agree that there's a need to distinguish between ordinary economic or white-collar crimes and the multiple forms that those take, and the abuse of public office for private gain. Corruption-related offences, essentially. Said it's a bit like distinction between burglaries and street crime. You need a strategy to deal with the two separately, and conflating these issues doesn't help in identifying strategies or discrete strategies aimed at tackling those abuses of public office that are essentially covered by corruption acts, which I know also deal with private sector corruption as well, but have some unique characteristics. I've noted with great disappointment that the Public Sector Standards Bill was allowed a lapse, and one of the reasons for that was because it would have allowed for the digitization of those returns by public officials, both at a local and a national level. There's a lot of confusion. If not confusion, it's a resistance amongst many of our public representatives to share as much information as they ought to. And that was covered in part by it was touched upon by the people remember the RT Investigates program on Standards of Public Office Commission, Standards of Public Office, and led to investigations into a number of county councillors. It also would have obliged our public representatives to share more information, including liabilities. And we know that it's rarely the case that public officials are accepting brown envelopes stuffed with cash anymore. There's only so much cash you can stuff in an envelope. It's much.
You're not ambitious enough, John.
Well, yeah, exactly. The point being that you're able you're able to transfer much larger amounts of money by essentially lending someone that money. Yeah. And currently, and this has been covered extensively in the Moriarty Tribunal as well. But there's still no obligation on our officials to disclose these loans.
And I think there was another interesting thing about the review, and this got a bit of media attention when it came out, was the recognition that corruption does not equal bribery or embezzlement. There are other modalities of corruption that are equally or perhaps even more damaging to society than just brown envelopes and dipping into the kitty. Nepotism, I think, is the one that they point in the review as being something that we have to wrap our heads around as being part of that family of corrupt activities. And you know, as you say, other things can there are other ways to do it besides stuff in the envelopes.
Yeah. No, I think there is a growing awareness of the impact of called relational corruption as opposed to transactional corruption, whether it be cronyism or nepotism. It has the same impact on public office, like on confidence in public office and the quality of decisions that and quality of services that public bodies deliver.
And that, just as you mentioned it, that confidence in public office and the kind of the anti-corruption norms that we have, the review notes that we tend, from the Eurobarometer, we tend to have quite strong anti-corruption norms in terms of how many people think it's never justified to take a bribe. But the thing that worried me, looking back over several waves of the Eurobarometer, sorry, is that number is ticking down slowly but surely. In other words, there is some sense, some evidence, you know, need to be further scrutinized, that Ireland's anti-corruption norm is moving in the wrong direction. And I think that's why this kind of report is important, not just to bolster trust in public office, these kind of activities to bolster trust in public office, but also to shore up our anti-corruption norm. Because another scary result from social science is that once you tip away from that good equilibrium where people generally think corruption is bad, you can fall quite far quite quickly towards the bad equilibrium, and it's very hard to recover. So, you know, we have to be eternally vigilant against that kind of thing. And again, that's why organizations like yours, John, are so important in keeping our anti-corruption immune system up and running.
Yeah, well, we can only do so much, Robin. Good to see that we have now an anti-corruption research centre dedicated to studying this phenomenon too. But I think when you go back to the role of the state here, it's important for us to understand that we need independent agencies to be, and not just civil society organizations or academics to be looking at this issue. And I agree. I mean, there are some very welcome proposals in the review. The advisory council, I think, could help shift the narrative or create a narrative within public service, highlighting the importance of this issue, keep it on policymakers' agenda. But one of the reasons why we had argued for or suggested in the first place a National Anti-Corruption Bureau is part because all of our state agencies right now are answerable to a respective minister. They don't have discrete ring-fenced budgets dedicated to tackling corruption. The Hamilton Review does note that the Gardaí are under-resourced. As far as I'm aware, there were around three, I think. Gardaí in the anti-corruption unit, which is based at the GNECB, looking into concerns about corruption-related offences. Without those ring-fenced resources and independence, operational independence, you're not going to see individual cases, essentially political corruption, investigated effectively. The Standards and Public Office Commission was flawed by design. You know, you have 6 commissioners responsible for overseeing investigations, 4 of whom are full-time office holders. You know, the Clerk, the Shannon, the Dáil, the Ombudsman, and the Controller and Auditor General. It's often really difficult to get those people in the same room to oversee an inquiry, and we know from recent cases as well that even where you do provide for offences in law, as was the case with the Lobbying Regulation Act, and someone breaks the law, that there are no penalties for breaking the law. Enforcement
needs to have teeth, and to have teeth, it has to have resources. as you say. I mean, I think part of what's going on maybe is that there's a realization that for, you know, the threat that corruption poses to existing political classes, and we can see this in some of the academic evidence coming out, that corruption scandals, prevalence corruption, is tied to the rise of support for populist parties in Italy and elsewhere. We can also see, you know, just simple functioning of the state is undermined by corruption. Myself and a colleague in the United States have a paper that came out recently that shows that more corrupt parts of the United States had lower compliance with their shelter-in-place orders because people don't trust the state as much, they view it as illegitimate. And I think that message is getting through perhaps to kind of current kind of political elites, that if they want to continue to kind of fulfill the role that they do in society, there's a danger that corruption, if left untreated, could radically alter the way in which our societies function, even in the developed world. Yeah.
I got to come back to my point. You need to create the institutions that are designed to protect the state from those abuses. We saw in the US how just one person could attempt to dismantle constitutional safeguards and legal protections against abuse of power, and how those constitutional institutional safeguards pushed back, and how important they are in protecting the public from abuse of public office.
I mean, one thing I took from the whole last 4 years was that, you know, honor is important, but you can't have a system that's entirely based on people acting decently. In other words, norms can only get you so far. They need to be backed up by, as you say, resources and independent agencies, safeguards and checks. Because quite quickly, the kind of person you have seeking office or fulfilling a particular role can change, and you can't have an honor system for governance. You want a system that that throws up honorable people, but you can't be reliant on decency and honor being a constant in your political process.
Yeah.
I might just come in, if you don't mind, because I'm conscious we've about just 5 minutes left to go. We actually have a question from Nicholas Power, and he has asked, is there a need for Transparency International to launch a more determined public awareness programme? This may in turn promote greater pressure on politicians to support legislative change. So John, I might hand over to you on that particular question.
Yeah, that would be nice if we had the resources. I mean, we will see the government lead, or we should see the government lead some awareness raising efforts from next year on. We're not sure what form they will take exactly under the leadership of the Advisory Council. We've been doing this work for 15, 17 years now, but and we come back to our final recommendation in our report. We need resources, and unfortunately, we're reliant on a handful of institutional donors supporting the work we're doing around whistleblowing, and there isn't that much funding available for the kind of work that Rob and I are talking about here. Large donors, we were reliant for a number of years on the generosity of the Joseph Rowntree Charitable Trust, a UK-based charity that funded our work here. But I agree, Nicholas, that we need to invest more in education and awareness raising. Hopefully we will be better placed to lead that work from next year on. But
and there were mentions of that as a function of the Advisory Council in the review, and that's great. But it is important that the awareness raising and education doesn't just come from an agency of the state. In other words, I think that there needs to be a mix of messages and approaches from my sector in universities, from civil society and John, and from government, that all put out the message of just how damaging corruption is, but that we're also not powerless to fight it at an individual level or as a kind of a collection of people. I think that's what the message needs to be.
Well, I mean, just one thing. I mean, I know we're pressed for time now, but one of the recommendations they did make, which really music to Judy's ears, was the need for judicial training and specialization in complex economic crime or corruption cases. And we'd suggest the same principle be applied to, the same effort be made to educate judges and adjudicators in the WRC and courts, labour courts, around the Protected Disclosures Act too. There's provision in Serbian law that obliges judges to take training on whistleblower law there, and we've seen, I think it was a 70% success rate compared to 10 times the success rate there than there is here. I wouldn't put it all down to our judiciary, but certainly I think there's a pressing need for education at all levels, not just the public, but professionals and senior officials too, around the law as well as practice. So yeah, I mean, there's loads, as I said, there's loads in there in our report. We go through a number of recommendations aimed at tackling corruption, not just protecting whistleblowers. I suggest anyone with keen interest in tackling white collar crime also has a look at the Hamilton Review, because there's lots in that too. So yes, this is to be continued.
Absolutely. And just a final question from Peter there in the chat. Do Transparency Ireland have an interaction with the unions in relation to whistleblowing? And I can answer that question, Peter. Yes, the Irish Congress of Trade Unions are a member of the Integrity at Work initiative. And we do, I've actually spoken at a number of trade union conferences and symposiums about our work supporting whistleblowers and the Speak Up Helpline. And we're always delighted, to engage with unions and union officials. So if you'd like to find out any more about that, please feel free to drop us a line, drop me a line directly. As I say, we welcome any opportunity to provide training or presentations to people involved in the union movement in Ireland. So look, I think that's all of our questions. We still have 22 hardy people who've stayed with us. So thank you so much for staying on the extra half hour. I hope you found it informative and worthwhile. As I said at the start, we always really do welcome your feedback and your questions. So if anything comes to you after this webinar today, if you're having a look through the report and you have any further questions or observations, please do feel free to drop us a line. I know we have a number of Transparency International members with us today. Thank you for your ongoing support for our work, and we always welcome new members, new donors to help us, do the work we do. So just have a look at our website if you'd like to get involved with us in any way. And finally, I'd like to thank Rob Gillanders for joining us today. Thank you for all the work that you do.
Pleasure.
BCU. Thanks to Judy O'Loan, our Managing Solicitor for the Transparency Legal Advice Centre. And finally, thank you to John Devitt, our Chief Executive at Transparency International Ireland. And I suppose all that remains is for me to say happy Anti-Corruption Day to you all. Thank you.
Thanks, Stephanie. Thanks,
Stephanie.
All the best. Take care.
Bye.